Having addressed the conduct expected of Senator Judges, the Chair now turns to Rule 18 and the persons expressly covered by it. The Chair makes this ruling not only in response to the manifestation and motion made by counsel for the respondent, Attorney Sheila Sison, on August 12, and after due consideration of Attorney Ligutan's explanation, but also on the basis of the Chair's independent findings of seeming violations of Rule 18. These incidents come after the Chair's earlier advice to both panels to designate the respective spokespersons so that the necessary and appropriate communications may be made within the limits prescribed by the rules. Since that advice has not been fully observed, the Chair now finds it necessary to restate and strictly enforce those restrictions. Article 18 of the Rules on Impeachment provides, "The presiding officer, the members of the Senate, shall refrain from making any comments and disclosures in public pertaining to the merits of a pending impeachment trial. The same shall likewise apply to the prosecutors, the person impeached, and their respective counsel and witnesses." This rule exists to balance the public's right to information on matters of public concern with the need to protect the integrity of the proceedings from public prejudgment. The rules of court apply only suppletorily to these proceedings. When the rules on impeachment expressly and specifically govern a matter, they control. Since Rule 18 directly governs public comments and disclosures pertaining to the merits of the pending impeachment trial, it is for this court, in the exercise of its authority and sound discretion, to determine whether a particular statement violates that rule. Henceforth, with respect to prior statements or conduct covered by Rule 18, the court shall extend grace, exercise liberality, and wipe the slate clean, tabula rasa, so to speak. From this point forward, however, Rule 18 shall be strictly enforced and be given full force and effect. Accordingly, the Chair hereby strictly enjoins all persons covered by Rule 18. You know who you are, and based on the records, we know who you are. From making public statements or otherwise discussing, sharing, or endorsing comments pertaining to the merits of this pending impeachment trial, and from engaging in trial by publicity, as they directly threaten the independence of the court, degrade the dignity of the tribunal, and risk turning it into a circus, and weaponize the media to substitute public outrage or actual evidence. We are in receipt of the appearances of the parties. So, ang covered po ng Rule 18 would be all those who appeared, both from the panel of prosecutors and the counsel for the panel of prosecutors. Chair earlier reminded the parties, designate a specific spokesperson. Wala pong problema kung hindi naman siya kasama sa panel. Walang problema kung hindi siya kasama sa counsel for the panel of prosecutors. The spokespersons are free to say whatever they want to say, but not, and there are limitations insofar as the panel of prosecutors and the counsel for the panel of prosecutors is concerned. Clearly, up to today, the spokesperson of both parties are still part of the counsel for the parties, some with more violations than others. So without enumerating the counsels where this rule applies, I think you know who you are, given the entries of appearance you've already made. These restrictions apply with particular force not only to counsel for the parties, but also to us, Senator Judges, and all other persons whose public statements are governed by Rule 18. Rule 18 makes specific mention of the respondent. It does not make mention of the complainants in this case, given the public nature of this case. So outside of the Senator Judges, outside of the counsels for the parties, particularly mentioned would be the respondent herself, as well as the witnesses called. Third ruling.